National Officer of NBA, Paul Usoro, said the EFCC on Friday re-arraigned the president of the Nigerian Bar Association, NBA, Paul Usoro, in a federal high court Lagos, on 10 counts of N1.4 fraud. EFCC had preferred was first arraigned before Justice Muslim Hassan on Dec. 18, 2018. Also named in the charge, is the incumbent governor of Akwa Ibom, Gov. Emmanuel Udom, who is described in the charge as being currently constitutionally immune from prosecution. Others charged are, the Akwa Ibom State Commissioner for Finance, NSECON NKAN, Accountant General of Akwa Ibom State, Emmanuel Udom, the Akwa Ibom State Attorney General, Emmanuel Udom and Margaret UKP. The aforementioned defendants are said to be at large. He had pleaded not guilty to the charges, but the case before Justice Hassan was subsequently transferred to another judge, Justice Akwa Ibo, following application by defense counsel. On February 14, Justice Akwa Ibo, in a ruling, had personally recused himself from the case on personal grounds, and said that the case file will be returned for reassignment to another judge. The case was reassigned to Justice Rilwan Akawa, who is the third judge before whom the charge is presented. On Friday, Mr. Emmanuel Udom appeared for the EFCC while Mr. Ifedeyi San appeared for the defendant. The 10-count charge was read to Usoro and he also pleaded not guilty to all counts. Defense counsel then made an application for the defendant to continue with the earlier bail granted by the previous judge, Hassan. This application was opposed by prosecution, who argued that having applied that the case be transferred from Hassan, the defense cannot therefore benefit from the bail granted by same judge. He said that although he was not opposed to bail, the court should grant its own bail terms as the matter was commencing afresh before it. After listening to respective submissions of counsel, Justice Akawa held that it is the court's view that bail is peripheral to a trial as it does not affect the substance of the trial, adding that the court has a discretion to depart from or adopt the earlier terms granted. In view of the circumstances, the judge held that the conditions imposed by his learned brother, Justice Hassan, be adopted. The court admitted the defendant to bail in the sum of N250 million with one surety in like sum. The court also ordered that the surety must be the owner of the landed property within the court jurisdiction, or a public servant not below the rank of a director in the federal or state civil service. The court also ordered the surety must deposit titled document with the court's registry and also deposit his per international passport with the court's registry. The court held that the above terms are hereby adopted, save to add that where the surety is a civil servant, his credentials must be verified by the court's registry. The court also adopted the terms granted by Justice Hassan, and released Usoro to a senior advocate of Nigeria, Mr. Effiong B. Effiong, pending the perfection of his bail terms. Meanwhile, Udom then informed the court that he had an innocuous application to make, and urged the court to issue a bench warrant for the arrest and production in court of the persons mentioned in the body of the charge and who are described as being at large. They include, Emmanuel Udom, Margaret UKP, Linus NSECON, and Emmanuel Udom. The court granted this application and ordered that bench warrant be issued against the named persons. He adjourned the case until March 18 and 19 for trial. NAN reports that in the charge marked FHC 418C-18, the anti-graft agency alleged that the accused committed the offense on May 14, 2016. The commission alleged that Usoro conspired with others to commit the offense within the jurisdiction of the court. He was alleged to have conspired to convert the sum of N1.4 billion, property of Akwa Ibom state government, which some they reasonably ought to have known formed part of the proceeds of an unlawful activity. The prosecution said that the unlawful activity includes criminal breach of trust which contravenes the provisions of Section 15(2), 15(3), and 18 of the Money Laundering Prohibition Act, 2011.